Welcome to the Self-Belief and Influence podcast, where we talk with people who have great influence in the Metro Detroit business community. We discuss all aspects of their journey, including the moments where they have had to draw deeply on their self-belief and inner drive to achieve their vision. My name is Keith Baldwin, and my co-host is Nathan Hardecki, and our podcast is sponsored by Regal Payments and Push Media. These conversations with our diverse guests will potentially make you re-examine your ideas about people, business, and life in general. Here's a taste of what's coming up today.
And so that's why this case was very unique, because the remedy I was asking for had never been given before. And so it really that's why it was heralded as one of the most important right to counsel cases since the right to counsel case of Gideon v. Wainwright, where the U.S. Supreme Court said in the 60s, you have to give poor people an attorney. You can't force them to go to court without an attorney. And that was in a New York Times article that said this is the most important right to counsel case since Gideon, because here it said that you have the right to effective assistance of counsel in the plea bargaining context. And the other thing that made this case so newsworthy is it applied to every state, every federal case. So every criminal case in the United States of America, this case applied to.
Let's explore and scrutinize together as we unlock the mind of today's guest to provide you with inspiration and tangible takeaways that you can choose to apply in your life. Our guest today is Valerie Newman, a 2023 inductee into the Michigan Lawyers Hall of Fame. And as you will hear, her career is equally fascinating as it is inspiring. Her current role since 2017 is as the director of Wayne County's Prosecutors Office Conviction Integrity Unit. Valerie, welcome.
Thank you. Thank you for having me, Keith. Happy to be here.
All right, we're really excited to have you here. And as you may expect with a Hall of Famer, her story is remarkable. In football Hall of Fame, the most well-known Hall of Fame there probably is, those players may well have reached the Super Bowl, but maybe not necessarily won or even made it there. And I don't know if you would equate the Supreme Court to be in the Super Bowl of your profession, but nonetheless, you argued a case in front of them, you won, and that case, Lafler v. Cooper, is heralded by legal rights groups and scholars alike as one of the most important cases of the Scalia-Ginsburg court term. There are so many aspects of your career and life from the past and present I'm excited to talk about, but since I mentioned the Supreme Court, let's start there. What was it like? Was there a moment, kind of maybe like a player walking out the tunnel, you were about to go into the Supreme Court for the first time, where you had a reflection of your whole life getting to that point?
Well, I don't know about that. I think it was more fear and terror.
Right.
As you walk into the court, it's really set up as a place of kind of, I would say, domination.
Okay.
So the justices sit well above you on a bench, and you argue from a podium that's so close to the justices that you cannot see all 9 of them at the same time.
Oh,
so
really?
you can imagine standing somewhere trying to make an argument or trying to have, I call it a discussion. You can't really argue with a judge. That's frowned upon.
Right.
But you can't even look each person in the eye at the same time. You kind of have to swivel like a bobblehead or something, swivel yourself around to keep eye contact. But I will say that when I put my hands on that podium, I felt like 200 years of history, like, shot through my body. I thought of Clarence Darrow and some of the other giants who had argued there before me.
Yeah.
And it was really a very, very exciting yet terrifying moment. And then I just kind of went into autopilot.
Yeah, I can imagine all your training kicks in then. And but yeah, I mean, were some of those justices on there, were they justices on the Supreme Court when you first got into law and you kind of known them your whole career? Or some of them are newer?
No, I don't. I'm trying to think of a few of them had been on there my whole career, like Justice Ginsburg.
Right.
But some of them were newer. Justice Sotomayor had just recently been appointed when I went to argue there. So it was a mix. But when you argue before the U.S. Supreme Court, I think what many people might not know is there's enormous, or you might expect, though. Enormous preparation, right? Like, so I traveled the country doing what we call moot courts, which is a mock argument in front of lawyers who are pretending to be Supreme Court justices, who have read all the briefs, and they grill you. I went to Georgetown. I went to Northwestern. Did one at my alma mater here in Detroit at Wayne State University, and of course one at my office at the time. And so I had argued this case over and over and over. Any brief to the Supreme Court has to be perfect.
Sure.
And it's hard to make anything perfect.
Yeah.
There's almost always a comma missing or a period in the wrong place or, something that on reflection, when you go back and read it, you're like, oh, how did I miss that? But I had like 23 drafts of my brief that went up there. It went through numerous people. I hope I've not read it in a long time, but I hope it was perfect.
Still stands up.
I hope it was perfect. So there's a lot of preparation.
How much of that preparation did you have to, because you mentioned, having to swivel, and how much of that did you had to change, like your body language, the way you addressed the court? Was there a large difference there in what you would normally argue a case?
Yes, there's a large difference, because when I would argue a case, at that point in my career, I'd been a lawyer for about 20 years, I think. And when you argue a case in front of the Michigan Court of Appeals or the Michigan Supreme Court, which I had done numerous times, the judges get to know you and you get to know the judges and the justices. And you have a reputation, and people know that you have a reputation, that, you're honest, they can trust what you say, you can answer the hard questions, and any good oral argument, I think any attorney will tell you, any good argument in front of a court should be more like a discussion around the dinner table, right? You're not arguing. If you're arguing, you're in a bad posture. Right. You want to be having a discussion. You want to be saying, this is the law, this is why I win, and being able to answer any of the judges' questions or state Supreme Court justices' questions. When you're arguing in front of the U.S. Supreme Court, most lawyers never do that. I mean, they take very few cases, and they take cases from all 50 states. So most lawyers will never argue a case in front of the U.S. Supreme Court. But when you get up there, there's only a handful of lawyers in the country that have argued there multiple times, who the justices might know. So almost all the people arguing are people, they don't know me. They've never heard of Valerie Newman. They don't know what my reputation is. They don't know anything about me. And so you don't come in with any credibility. You just come in as a lawyer, and you have to earn that credibility quickly, right? So you have to adjust the way that you approach things, and you have to follow the rules. There's entire books written about the rules for arguing before the U.S. Supreme Court. Right. It's kind of terrifying. And when you go to argue there, they give you a little handbook about all the things you can and cannot do. So there's actually rules about how you can address the justices. There's a clock right above the justices' heads, the Chief Justice. There's a clock there, and there's a rule. You are not allowed to look at the clock.
Wow.
I mean, I'm talking, these rules are like,
it sounds like
down to the minutia of what you can and cannot do, what you can wear, where you can stand, what you can do with your hands. I mean, every single thing is scripted.
Yeah, if you weren't nervous enough about the argument you were doing, now you've got to remember every little movement you're doing.
Well, they don't. Yeah. At a lot of courts, they have nameplates, right? So they'll have Judge Smith, whatever the judge's name is. At the U.S. Supreme Court, of course, you're expected to know the names of all the justices. Of course, I did. But when you're nervous, you might forget, right? And you might call someone by the wrong name, or something embarrassing could happen. A friend of mine told me a story when he was up there arguing. Sandra Day O'Connor was on the bench, and she was not there when I was there. And he called her Justice Connor instead of Justice O'Connor. And she corrected him 3 times. Like, these are Supreme Court justices. You do not, no matter how nervous you are, call them the wrong name.
3rd time had been
tough. It was brutal, right? So you're thinking, in addition of being focused on your argument, which of course you know well, but you're getting rapid fire questions from, imagine if we were here right now and there were 9 people firing questions at me. And then the other thing that I was very terrifying is you're supposed to answer your questions according to seniority.
Oh, okay.
So if multiple people are asking you questions, you're supposed to answer the most senior justice's questions first and then go down from order of seniority. Now, you're getting they're asking you questions and they're talking over each other and they're coming at you. And then you have to remember not only what question did they ask, but who's the most senior justice so you can respond to that person
So
first.
do they not ask questions and then wait for an answer? Does one ask a question and another one quickly asks a question before you get a chance to answer?
Yes.
And I can't imagine they sit in order.
They do sit in order.
Oh, they do? Oh, okay,
They
well,
do.
that's good.
But still, you're sitting there trying to remember every question that's asked of you, be able to answer it, and then be able to answer it in the order that they're asked. And sometimes you don't want to answer in that order because it would make more sense to answer a different question because it can lead into your answer to the other question. It's just like, it's quite an experience. And I did it twice. The second case I lost. But at least I knew, a little bit about, what you're heading into. The second time the case was much more difficult and it had not been my case from the beginning. So the first time.
Yeah, tell us a little bit about the first case, Lafleur v. Cooper, briefly what it was about and why it was significant.
Sure. So Mr. Cooper had been charged with assault, had been charged with a crime that he had clearly committed. All right. He was almost basically caught in the act because the police were around the corner. And all Mr. Cooper wanted his attorney to do was negotiate a good plea for him. He knew that there was no way to go to trial and beat this case. But yet he went to trial and he was convicted and he was sentenced to 15 to 30 years. And at the time I wasn't what's called an appellate attorney. So I come into the situation once someone has been convicted and sentenced, they want to appeal their conviction, they can't afford an attorney. I worked in an office where we took cases for people who could not afford to hire an attorney. It's called the State Appellate Defender Office. And so I met with Mr. Cooper, and Mr. Cooper told me what I thought was a fantastical story, that his attorney had told him not to accept a plea because he could do better if he went to trial, because he couldn't be convicted of the charged offense. I will tell you right now, I did not believe Mr. Cooper. Not one bit. No attorney. There is just, I could not believe that an attorney would say definitively that you can't be convicted. You might hedge and say, I don't think you'll be convicted, but who's going to say, I'm telling you legally you cannot be convicted of this crime and you're going to do better because you'll get convicted of a lesser crime than this plea deal they're offering you. But like a good attorney, I took my client at his word and I called up the attorney and I said, hey, I just came from visiting Mr. Cooper and this is what he tells me. And he's like, oh, I'm so glad you're appointed to this case. I don't know how he got convicted. He only shot her below the waist. I'm like, oh my gosh, okay. So I'm thinking Mr. Cooper was telling the truth. And so I talked to the attorney. I said, well, will you sign an affidavit? Because I want to file a motion in court. Oh, yes, of course. I'll sign an affidavit. And all the way back from the prison, I'm thinking this man's going to talk to his friends or other lawyers, and he's going to figure out he can't sign this affidavit because it's admitting malpractice. And so the very next day, the first thing I did was draft up that affidavit, walk over to his office, and get him to sign it. And he signed it. So this is like one of those cases, every step of the way, you're like, this is going to fall apart, right?
So if the lawyer hadn't signed it, then you couldn't have carried it on.
I could have. But then it would have been Mr. Cooper's word against his word.
Okay.
But he's coming forward and saying, yeah, Mr. Cooper's telling the truth. I taught him this. I don't know how he was convicted. And so we file a motion. We go into the trial court, and I argue to the judge, and we have a hearing. And the attorney gets on the stand, raises his hand, swears to tell the truth, and says he shouldn't have been convicted. Like, he shot her below the waist. He can't be convicted of assault with intent to murder. In court, in open court. And the judge is incredulous. The judge is mad. I think he thought the lawyer was lying to try and
Everybody thinks this guy's lying.
right, to try and help out his client who got a bad deal. Ultimately, the judge says, sour grapes. You know what? You had a deal on the table. You said no. Now you have sour grapes because you were convicted and you're serving a lot more time. Denied.
Wow.
And I go to the Court of Appeals. Denied. And I go to the Michigan Supreme Court. They won't hear it. So then we can go into federal court because it's a federal constitutional issue. It's a Sixth Amendment right to counsel issue. I'm arguing that his counsel was ineffective. So there's a very narrow way to get into federal court from a state court conviction, and this is it, right? And this is a perfect setup. So going to federal district court, I win. The state appeals, we go to the Sixth Circuit Court of Appeals, I win again, and the state appeals again to the U.S. Supreme Court. And at this point, I'm thinking the U.S. Supreme Court, they take like 0.1% of all cases, right? There's no way they're ever going to take this case. But I start getting phone calls from law school clinics that have Supreme Court clinics, and everyone's interested in this case. And I'm thinking, all right, I must be missing something, right? And so
can I just ask, not to interrupt, but
No.
why is the state, once you've won once, why do they keep appealing? Why can't they just see, is it just, and actually doing kind of a lot of research before speaking to you, it seems in a way that the system's set up to preserve its process rather than find justice at times. Is that true? And why wouldn't the state just be like, okay, you won your appeal, let's just move on. There's other cases in the world.
Keith, that if I could answer that, that's the $64 million question.
Right.
The entire criminal process is set up to preserve finality. And so when there are mistakes, it's extremely difficult to undo them. And that is one of the seminal problems with the legal system, is that once you are caught up in it, it is almost impossible to untangle that web. And this is a perfect example. Not only did the state lose, but the state lost. The Sixth Circuit opinion has one of my favorite sentences ever in my 3-decade-long career as a lawyer. And the Sixth Circuit Court of Appeals said that no amount of deference could save the state court's opinion. That's a very harsh statement for any court to make about another court. But coming from the Sixth Circuit Court of Appeals to make that comment about the state court, it should have been a lion's roar to the state to let this go. No amount of deference could save this. It was that bad. But I think one of the reasons the state took it up at that time was they had been on a winning streak. So for 6 years in a row, they had never lost a case in front of the U.S. Supreme Court. That just goes to hubris, in my opinion. But that's just one person's opinion.
Right.
I think the other reason they took it up is this really was a novel issue. So the U.S. Supreme Court had taken up a similar case 2 years prior in a death penalty case. And the parties had settled, and the death penalty was taken off the table. And that defendant got life in prison. And so the pump was kind of primed for this issue. And the issue is interesting because there's two sets of cases in existing law at the time. There's one, if you had a trial, and the trial was unfair, and you had a good legal issue that you could prove it was unfair, then you get a new trial. If you took a plea and you could show that the plea process was unfair, then you get a new plea. I was right in the middle. Mr. Cooper had a trial. I was arguing that the trial was unfair because of his attorney's ineffective assistance on the plea part of it, of not letting him take the plea. And I didn't want a new trial because what good does a new trial do my client? He's going to get convicted again. He was caught red-handed. The victim knew him. He shot her. There was no dispute about the facts. He wanted the plea back. And so that's why this case was very unique, because the remedy I was asking for had never been given before. And so it really that's why it was heralded as one of the most important right to counsel cases since the right to counsel case of Gideon v. Wainwright, where the U.S. Supreme Court said in the 60s, you have to give poor people an attorney. You can't force them to go to court without an attorney. And that was in a New York Times article that said this is the most important right to counsel case since Gideon, because here it said that you have the right to effective assistance of counsel in the plea bargaining context. And the other thing that made this case so newsworthy is it applied to every state, every federal case. So every criminal case in the United States of America, this case applied to.
Yeah. Now, today, the Supreme Court, is in the news, I guess, more than it used to be, and it can seem a bit polarized. But that decision was still 5-4 back then.
Yes.
Why do you think it was close?
I think it was close because it was new ground. Because the remedy for an unfair trial is a new trial. The remedy for an unfair plea proceeding is a new plea. And the dissenters thought that this would open up a can of worms. So everyone who went to trial, everyone who was offered a plea offer, who then went to trial and lost, would come back and try and reopen. Again, I'm going to go right back to your point you made before, finality.
Right.
The fear was this would be the undoing of the criminal legal system, of the trial aspect of it. Because everybody who went to trial and lost would then come back and say, oh, I should have taken the plea and I didn't because my attorney screwed it up, which of course didn't happen. The bar is high. It's hard to bring this issue. It's hard to win the issue. To me, a lot of people tried to take this case away from me. Once the Supreme Court granted cert, which means accepted the case, I got calls from every boutique law firm in the entire country. Mm-hmm. And the pitch was basically the same. You're a poor public defender. You don't have the resources. You've never argued in front of the court before. You can't do this, right? You're not equipped to do this.
Did that embolden you?
It did.
I bet.
Absolutely. But you have to be humble too, right? Uh-huh. You have to know, I have not argued in this venue before. This is a very specialized venue. There are different rules, and I don't want to jeopardize my client. And so I had to make a decision, and my decision was I can learn the rules of the court. I can argue in a different court. I can prepare for everything I don't know by learning about it, reading about it, practicing, talking to people who have argued there. I can do my research, and I'm a lawyer. I can do all of this. But nobody is going to bring the passion for Mr. Cooper that I'm going to bring. For all these other lawyers, this is a notch on their belt. This is another opportunity to say, I argued in a case before the U.S. Supreme Court. Win or lose, I mean, not that they don't care about winning. Everyone cares about winning, but not like I did.
Do you think as well, because I know you've done a lot to help women in the workplace and break glass ceilings. Do you think part of that, those phone calls were patronizing as well, because maybe you were a woman, or it was just more they just wanted the business and take the case away from you?
I think it was both. They were all men. I did not get one phone call from a woman. So yes, I think it was also some patronizing as well in what happened. And the way I vetted people is I said, look, I acknowledge that I've never argued before the U.S. Supreme Court before, and I'm going to do the best job that anybody, I feel that if I can't do it the best, I'm going to hand it off to someone else, because I'm not going to jeopardize a client to argue before the U.S. Supreme Court, no matter how amazing that might be. I would never do that. And so I asked people if they would work with me. You've argued in front of the U.S. Supreme Court 5 times, 10 times, whatever it might be. Will you partner up with me and be that kind of sage advisor? I'll put you on the brief. You can second share it, but my name is first on the brief, and I'm going to argue this case. Nobody would do that. They all wanted it for themselves, except one person. There was a guy named Jeff Green at Sidley Austin in Chicago, and he was terrific. And he said, absolutely, I will partner with you. My firm will help you. And he was a terrific partner. And that was really great. But he was the only one.
Everyone else's ego was too big to...
That's right. They were too big to even, and I'm not going to name names or give any identifying information, but even the one person who I worked with on what we call a brief in opposition. So when the state filed their cert petition, I filed a brief in opposition to their cert petition. Actually, I wasn't going to because I figured they would never take it. But then I was ordered to. So I filed a brief in opposition, and I worked with one of the law school clinics. And I was promised that it would be my name on the brief. I would file it, but, I'd work with them because it's great work for a student. And I've taught for decades. And so I'm all about giving students this kind of terrific opportunity to write a brief in opposition to the U.S. Supreme Court. Is pretty amazing as a law student. And that person lied to me and put their name on the brief and submitted the brief. And I mean, it was a good learning experience for me, but it was a terrible betrayal, I thought.
Yeah. Did you confront them, and what did they say about it?
Once it was done, and it just made me, again, I think Nathan asked, did it just, solidify the fact that, did it embolden me? It was the word that Nathan used. Yeah. And it just made me more sure that I could not trust other people to... I'm sorry.
No, you're fine. There's so many things that touch here.
to adhere to, what they promised. So it meant that I had to maintain control of everything.
Sometimes those negative events lead to powerful motivation. I've mentioned before the story of Barbara Corcoran, the lady on Shark Tank. Yeah. She was, her ex-husband said she couldn't do it, and that basically was a huge driving factor and helped spur her on. Do you feel negative motivation as being a big source, or more it's just you've confidence in your training over the years and the self-belief that's given you?
I think it's a combination, right? Yeah. I think if someone had come out of the gate, kind of like Jeff Green did, and said, I'm willing to work with you, I might have taken more help and build some trust, right? So if that had happened at the brief in opposition stage, things might have turned out differently. I don't know. I think ultimately, as scared as I was, and I will freely admit it's a very scary situation, I was confident that no matter what deficits I might have of not having argued there before, not being from a big law firm and having enormous resources at my disposal. I mean, basically, I had to do everything myself. I had to make my arrangements and make my moot court arrangements. And I didn't have anybody who was helping me. And I still had cases to work on, like other clients that I had to take care of. It's not like a big firm where they're going to say, here, take 3 associates and a full-time secretary, and, we're going to do all the research and do everything that needs to get done. I had a companion case called Missouri versus Fry, and people were really excited about that case. They didn't like my case, but they liked Missouri versus Fry. And there were a number of groups that wanted to come in and write a friend of the court brief, known as an amicus brief. And they only wanted to write it for Missouri versus Fry, and they wanted to leave poor Mr. Lafler out of it. And so I had a whole bunch of work to do to convince them that not only should they write it on behalf of both defendants, Lafler and Fry, but actually I had the much better case, because everyone thought my case was terrible and I was going to lose, and they thought Fry's case was great and he was going to win. I'm like, no, you have it backwards. You really do. And that took a lot of work and a lot of time, but I could not fathom having a friend of the court brief written just for Fry when these cases are being argued together, right? I mean, the court sees them as, if not the same, very similar legally. Why would and there were some big groups. It was the American Bar Association and other, very weighty groups that were weighing in. And so I had that going on as well. And and there's rules about that as well. right? Like I cannot control the amicus. So I can't tell them what to say. I have to basically stay out of it. And so, I had to make sure that I didn't step over any lines in advocating for my client to be included in the friend of the court briefs, which ultimately I'm very happy to say he was, and all of them, and everyone was very happy that they did when the outcome, when the decision came out.
That's great. Not to jump around too much, but I want to kind of go back to your path into law.
Sure.
For me, when I look back, kind of my career, essentially, I didn't really find my niche until my mid-20s of where I kind of wanted to go. I feel like maybe lawyers, medical, or maybe engineers, they're people who know at 15, 16, and they're off. They want to do that. And looking at your schooling, I mean, you went to U of M for your bachelor's, then you go to my country to go to Cambridge for your master's, then you do another master's at Cornell, then you do a Juris Doctorate at U of M. So it seems like fully planned out, but I know you've mentioned to me that it kind of took a turn, that you weren't originally looking at law.
That's not my background.
Uh-oh.
I don't know where that came from.
Uh-oh.
You made me much more educated.
Edit.
45.
You gave me a lot more degrees than I have.
It was on the internet.
Fire the research intern.
Yes.
No.
So you didn't go to U of M.
I went to U of M for my bachelor's. Then I worked for 4 years, and then I went to Wayne State Law. There's no Cambridge or Oxford.
We could leave it in there.
I love it. It makes me sound much more educated than I am.
All right, I will start that again. All right. Who did that? Okay, so I'd like to take it back a little bit into how you got into law. Law for me is something that I think of that people do a lot of schooling and they know from potentially an early age because it's a path with a lot of work ahead of it, maybe like medical, maybe like engineering. Was that your path? Or I think you mentioned to me before we spoke that you had a work experience which kind of made you look at law.
Right. So I always knew that I wanted to do an advanced degree. But when I graduated from college, I had a lot of debt. I have some anxiety about being in debt. And so I wanted to work and pay down my debt before I took on any new debt going on for a second degree. And so I went into retail, and I had a very negative experience in retail, which kind of motivated me to accelerate my timeline to apply for law school. So
there's that negative motivation again.
I know, it keeps coming up, even though I say it's not that motivating. But
what happened to you?
I just had a poor work experience with a boss who I was up for a big promotion, and it turns out that the woman who received it was having a relationship with the person who was making the decision. So even though I was more qualified, I'd been doing the work longer, I didn't get it. And then I wound up having to work for her.
Wow.
And it wound up being not a very pleasant experience, but I believe you learn from everything that happens to you. So nothing's a mistake, and it happens. You have to learn from it. I had to learn to deal with it, and I had to figure out what I wanted to do. So I had actually taken the LSATs a year before this happened, and I was on the fence about, do I go, the LSATs are the law school entrance examination. And I was on the fence about, do I go to law school or do I keep doing what I'm doing? I'm up for this big promotion. This, maybe is this going to be a little bit longer of a career than I had anticipated. And then after that, I said, oh no, I'm going to law school. So I was kind of already 1 foot in the door because I had already taken the test. I had done quite well on it. And so I applied to law school, got in, and went from there. But I was not one of those, I want watching TV or I want to be a lawyer at 10. I always wanted to help people. I always kind of thought I would be a psychologist. I'm interested in people. I'm interested in the way people work and, helping them. And law was kind of second, but I figured you can do anything with a law degree. So I didn't have to practice law, but it would help me no matter what I eventually wanted to do. And that's why I decided to go to law school. And then I was lucky enough to get a full ride scholarship at Wayne State. So that made it kind of easy because all I had to do was pay my living expenses and school was paid for.
How did you get that scholarship?
It was offered to me. I had very good LSAT scores and good grades from U of M, and I guess it made me an attractive candidate. So
Okay, great.
I was very fortunate, and Wayne State is a fantastic law school, and I knew I wanted to go to an urban law school because my commitment was in public interest.
Yeah.
So I wasn't looking to go deeply into debt and go to a top tier law school when I knew that I wanted to stay in Michigan. I really wanted to go to the East Coast, but East Coast or Michigan, and probably was going to stay in Michigan because my family's here.
Yeah.
And wanted to do public interest work, which was never going to make me a lot of money.
Right. Yeah, I really want to get on to your current work at the Conviction Integrity Unit because there's so much to talk about there. But I do want to ask, because some of the other work you did on your way there, as I mentioned, is about helping women break through glass ceilings and discrimination at work. Did you face some of that yourself, and do you think that's got better over the years?
Absolutely. There's no question that there's still a lot of discrimination in the workforce, and there's a lot more women lawyers. I think law school classes these days are 50-50 or maybe even 55-45 in favor of women. But still, there's decades and decades and decades of tenured professors and people in the workforce. It's still a very male-dominated workforce. And so anytime I think you have an imbalance, there's going to be issues that you encounter. And you have to determine, I always tell students when they ask, well, what do you do? It depends on you and it depends on your situation. You have to do what you feel comfortable doing. Some people are not comfortable confronting it in the moment. And that's okay. You shouldn't make yourself uncomfortable, I think. You have to just get to a point where you're comfortable doing something about it. Sometimes you can't do anything about it. I had a Court of Appeals judge who's no longer on the bench, who would hijack any argument I had in front of him, flirting with me from the bench. And I was not in a position to do anything about it. I was there to advocate on behalf of a client. I had to do my best to keep my composure, find a way to advocate on behalf of that client. And I relied on the other judges, because when you argue in the Court of Appeals, there's 3 judges to help me out, which they almost never did. I went to my boss at the time, who was a woman, and I said, I have this problem. I need help. I talked to the chief judge. Something has to be done. And she wouldn't do it. And so I thought, okay, well, what can I do? Because I have to protect my client. I mean, I'm upset for myself, of course, but my top priority is my client. And I thought, okay, I'm going to send other people in to do the arguments, because that would take this away. It was horrendous. He treated anybody who stepped in for me horribly. And all he wanted to know is, where's Miss Newman? Where's Miss Newman? Where's Miss Newman? So that didn't work. So then I decided, all right, if my boss is not going to do anything, I have to do something. And I went and talked to some of my friends who were judges on the Court of Appeals and said, I need help. What can we do? And it did stop, but it was always uncomfortable.
Yeah. And there's no like ethics arm that can help with something. I mean, that seems incredible.
Theoretically, I could have reported him to the Judicial Tenure Commission, but
could create other problems.
That can create a lot of other problems, and I don't think it takes a lot for the Judicial Tenure Commission to take action, and I didn't think it would be actionable.
Gotcha.
So it was. I mean, if the other judges are not stepping in.
Mm-hmm. What year was this roughly?
This is probably 10 years ago. So
wow, 10 years ago.
That's
2013-ish.
And I thought you were going to say like late 90s or something. I mean,
no.
I mean, don't take this question like I don't believe you, because I do, but like it's so fantastical in a way. Like, how was he flirting with you? What was a couple of quotes that, I mean, he's a judge and he's openly flirting in the court?
Yeah, so our arguments are between 15 and 30 minutes, depending on whether or not we're opposed in the Court of Appeals, and it would just be a constant stream of personal Miss Newman, how you doing today? Oh, Miss Newman, are you still teaching? It'd just be Miss Newman this and Miss Newman that, and it was, nothing about the case, and you can't not answer the questions.
Right.
He's the judge, and so you're put in a very precarious position of trying to navigate that. Yeah, no, he was shameless.
Wow.
So that's an incredible power imbalance. I know we talk a lot about power imbalances, but it doesn't get much more imbalanced than that, does it?
No, it really doesn't. And it's really, that's the only, that's an extreme example. And I would say that's the only extreme example I have in my career. But, women will tell me all the time, or they'll come up to me and they'll feel like the judge was flirting from the bench, or the judge called him up and was a little too friendly, or whatever it might be. I mean, I think whenever you have a power imbalance, that can happen. I have judges who would call me in the back anytime I set foot in their courtroom. Oh, Miss Newman. I had one judge, if I set foot in his courtroom, the courtroom could be absolutely packed with all these lawyers waiting to have their cases heard. Oh, Miss Newman, we're stopping court proceedings. Come in the back. And he just chat like 20 minutes, a half an hour. That's embarrassing, because then you walk back out and all these lawyers are waiting, and all these citizens are waiting to have their cases heard, and they're wondering why were court proceedings stopped.
Yeah. For
Valerie Newman, who walked into the courtroom unannounced, so you have to stop doing those things, right? For me, there might be some people who would want to take advantage of a situation like that, but for me, it was incredibly embarrassing.
I can imagine.
And so I would stop that. But sometimes you have to go see judges. That's my job. I'm a lawyer. You have to go into a courtroom. And if every time you set foot in a courtroom, a judge calls you in the back, it's, and is, maybe a little bit overly friendly, that's why you have to figure out who you are as a person, how you can comfortably handle that. Are there alternatives? Do you go into court with somebody else? So there's two of you. What's the best situation? What's the best way to handle it? Because if you just tell a judge, you're making me uncomfortable. I really don't want to go in the back with you. That judge might never treat you the same again. And that's okay. Yeah. That's okay for me personally. I can take it. But if you take it out on my clients, what am I supposed to tell clients? Oh, go find another lawyer because I can't represent you in front of this judge because he has a grudge against me because I confronted him on his sexism. Mm-hmm. So it becomes an area that's fraught with, in the real world, with what do you do? How do you handle it? I think I've always, done my best to handle it well according to the circumstance. But for me personally, my first priority is never myself. It's always my clients and not jeopardizing their case.
Yeah. Wow. Those stories in a way segue well into your current work, because maybe a stereotypical public perception is that, the law works pretty well, and maybe, if someone's convicted, they probably did something. But the more you hear of this malpractice and this other thing, you start to uncover and realize how things can go wrong in the legal system. And I know since you set the unit up, you've had 2,000 requests to look into certain cases.
Yes.
And you've helped 35 individuals.
36.
36 now. Another one just happened there. And I was thinking about it, and again, trying to put myself in the public perception, watching some movies and Hollywood movies and the actual real life. Maybe not the most famous one, but A Few Good Men. You've seen that, right?
Of course.
Yeah, Tom Cruise. He's hammering Jack Nicholson, and finally Jack Nicholson confesses, and then the movie ends and justice is done and everyone walks off into the sunset, basically.
Right.
But even with a confession, like from another person saying that I did it, the person you convicted didn't do it, that's not the end of the movie. That doesn't automatically get that person released. There's, like we talked about earlier, processes and finality that make it very tough. When you took the role as director, what were some of your hopes and aspirations, and were you aware of all the challenges you were going to face?
Oh, I was not aware of all the challenges I was going to face, not by a long shot. And you would think after 25 years doing public defense work, I would be aware of everything, not even close. So I took the job with a lot of trepidation. I had been, like I said, a public defender for 25 years. I had gone heads up with the Wayne County Prosecutor's Office on many high-profile innocence cases. I was one of the lawyers for Devontae Sanford, who was a 14-year-old wrongly convicted of a quadruple homicide. I was the lawyer for Tommy and Raymond Hires, two brothers who were wrongly convicted of murder, and we got them out after 25 years.
The Devontae Sanford one, that was a situation, like I mentioned, where someone else admitted the killings, correct?
Yes. Someone else admitted the killings 2 weeks after he was sentenced. 2 weeks after he was sentenced, and it took us 10 years to get him out of prison. And he was 14 years old at the time that he was convicted.
And one other thing about that case, 'cause I was obviously reading about it a lot, I thought was interesting. I was reading a statistic, I don't know if this is true, that African-American men who are innocent are 7 times as likely to be convicted as innocent white men.
Absolutely.
So there's definitely some racial prejudice there. But in the Devontae Sanford case, both of the officers who were at fault were African-American themselves.
They were.
So that obviously doesn't fit. Why did that happen?
It does fit. People think of prejudice as kind of a one-way street. Like white people are prejudiced against black people are prejudiced against white people. But prejudice can be socioeconomic. Prejudice can be any number of factors, right? And so just because they're black police officers and it's a black defendant doesn't mean that prejudice doesn't creep in. So in Devontae's case, the primary bad actor, there were 2 primary bad actors. One was a Commander Tolbert, who drew a sketch and claimed that Devontae had drawn the sketch. And so only the person who had been inside the house could have possibly been able to draw a sketch of the scene. And he was caught in that lie by the Michigan State Police. And that was the primary reason the prosecutor's office dismissed the case. But the other person who played a role in this was Officer Russell, who claimed he took a confession from Devontae. And remember, again, Devontae was 14 years old and he had some cognitive deficits, and he was interviewed without any parent or guardian being present. And he got caught up in this because he left the house. He lived nearby the crime scene. And his mom went out and he left after her. And the police were canvassing the neighborhood. And so he just randomly got caught up in a police canvass. And when the police officer talked to him, he said, "My uncle is Bill Rice." And Bill Rice was a well-known homicide detective at the time. And the officer who was talking to, Dale Collins, is like, "Bill Rice is my best friend. I don't believe you." And Devontae's like, "Call him." And so Collins calls Rice, and Rice says, "Yeah, that's my nephew." He's like, "He didn't do this. He was with me all night, and I dropped him and his mom off at home when we were done. I'm confident he didn't do this, but he knows what's going on in the neighborhood. Maybe he can give you some information." That's what it took to get Devontae into the grip of the police and never get out. And he never got out. There was nothing that connected him to the murder. He didn't know the people, and no one had ever seen him there. There was no physical evidence. There was a woman who was shot and survived under the bed who said that the person talked to her and said, "I'm not going to hurt you." And there was a young child in the bed who was uninjured. And she, the only real evidence against Devontae, so you had this crime scene sketch that supposedly only the perpetrator could have drawn, marked with where the dead bodies were. Russell, actually, I'm sorry, Devontae didn't confess. What Russell's role in it was Devante says that Russell showed him a camera shot of where the bodies were. And that's how he was able to mark on the sketch where the bodies were. And this woman who claimed that she could do a voice identification of Devante, like years, 6 months after it happened. After she had described the perpetrator as being tall and skinny, and Devante's a 14-year-old chubby, not chubby, but not skinny,
right,
and not tall, 14-year-old kid. And he goes to trial with perhaps one of the worst attorneys in the entire state of Michigan. This gentleman is now disbarred.
Wow.
But he had been grieved and suspended and, just had a horrible track record. And they're going through trial, and the police and the lawyer are pounding on Devante's mom to get him to take a plea deal, because otherwise he's going to go to prison for the rest of his life at 14 years old and never see, he'll come out in a pine box. And she convinces him to take a plea deal. And 2 weeks later, Vincent Smothers is arrested, and he confesses to 12 murders. 12 murders. The police believe him on 8 murders. And the 4 murders, known as the Runyon Street House, which is what Devante was just convicted and sentenced to prison to 60 to 90 years for, no one ever comes back and questions him about those 4 murders. They only question him about the other 8. And when he inquires, why isn't anyone asking me about the 4 Runyon Street murders, he is told by Officer Russell, we already got that guy. And he says, you don't. I did that. I know who I did it with, and I know that he's not in custody. So whoever you have is not the person who committed those murders. So the police knew this, the prosecutors knew this, and nothing. I don't know what the prosecutors know. I know the police knew this, and nothing was ever done. And we fought for the next 9 years to get him out of prison.
For the police, in the investigation, is the motivation there the finality, like you described earlier? They got a guy, they want to close the case. That's it.
How do they look? They claim that he drew a map. They claim that he put X's where the bodies were. They claim that he gave, them all this information. He pled guilty in court.
Yeah, I can see that after, but why do they want to railroad him in the first place rather than, okay, he's probably not involved, let's keep looking?
That I can't answer. If we could answer that question, we'd go a long way to eradicating wrongful convictions, right? Like, why do you want to... what is it that makes you so certain that this 14-year-old kid could have gone into a known drug house where people were armed and expertly executed 4 people? That's not easy to do.
Yeah.
And Smothers was a contractual hitman. He was someone the police had been after for a long time, and they caught him. And then there's a whole nother web of things that happened where they found a whole bunch of weapons connected to Smothers told him where to find these weapons. And one of the weapons was stolen from this drug house where the murder happened, where the Runyon Street drug house where the murders happened, and was used in the murder of a police officer's wife. It was a hit that the police officer ordered on his wife. And so Vincent Smothers is connected over and over and over to this crime scene. The person across the street from the Runyon Street house is a police chaplain. He heard the shooting and came out with his gun and fired at the people as they left the house. He testified that there were 2 people, both of whom were very tall, one who is very skinny, and all dressed in black. And I forget how tall Smothers is, but I think he's like 6'3", like 190. Tall and skinny. And, he was not with a professional hitman does not use a 14-year-old child.
Right.
As, the person that's going to back him up.
Now, Smothers, is he life in prison right now?
He is not life in prison. He was offered a plea deal, and I can't remember how much time he's doing, but it's not life.
Wow.
Is that just because of cooperation? I mean, what gets a contract killer to not have life in prison? I'm sure the justice system is very strange to me.
The legal system
I'm sure it's even stranger to you.
It's very strange, especially after he confessed in a lot of detail to 8 murders. And had they spent any time at all, they would have connected him to these other 4 murders.
So even after Sanford's released, he's then not charged with those 4 murders?
Correct.
And you can tell by Nathan's deep inhale there. It's just, but this is something you face
Truth
all the
is
time, right?
Yeah.
I mean,
truth is stranger than fiction.
and you have, I was reading, there's 100 wrongful conviction units across the country.
Yes.
Some have never even got a result. You have 36. I mean, and I think the general public who want to, gloss over things think that is what we described as maybe just a one-off, but it's not, right?
It's not a one-off at all. So let me give you something to think about and your listeners to think about. Would you get on a plane? So the accepted statistics are somewhere at a minimum 3 to 5% of the cases that go through the criminal legal system are of innocent people. All right, let's use 10% because it's easier to do the math. Let's say it's 10% because it can be upwards of 10%. Some people think no because there's so many uncovered innocence cases. Example, you picked up for a misdemeanor and you spend 7 days in jail, right? And your attorney comes to you and says, just plead to it. They'll give you time served. You can move on, right? And you didn't do it. But are you going to keep fighting it and coming back to court, especially if you're poor, especially if you don't have transportation? Come back to court, you could lose your job, all the things, all the barriers, right, to fighting it? Or are you just going to say, okay, I'll plead guilty and I can walk out and I can go on my way? And so there's a lot of cases where people are incentivized to accept responsibility for something they didn't do because it's easier than fighting it and going forward. So let's say 10%. So I don't know how many flights take off every day, but let's just use 1,000 flights. All right, 10% of 1,000 is 100. Would you get on an airplane if you knew today 100 airplanes were going to crash?
About 3 to 5% still. I wouldn't get on the phone.
Okay,
Yeah.
right.
0.01%,
Yeah.
right?
Would you get on an airplane if you had any statistical number that was like a guarantee? Yeah, right. Let's say 5%. That's 50.
Yeah.
We know that. We know that for a fact. Would you fly? No one would fly. Right?
Yeah.
Airline transportation would be grounded, and we would figure out how to fix it. We need to do the same thing with the legal system. We should not be trusting a system where there is that kind of an error rate. There was they found a 10% error rate in the Detroit Police Department crime lab that was testing ballistics, firearms testing, and things of that nature, DNA testing. They shut it down because that was so outrageously unacceptable that the lab could not continue to operate. So we have to ask ourselves, why do we accept that kind of error rate in the legal system? What is it? Because it doesn't affect us? You think it's other people? You think it's not a big deal? But people...
I think it's so easy I feel like, especially now, it seems like as we progress further and further in social media, that once you're arrested, you're guilty.
Yes.
It's so easy for the public, right?
Beyond a reasonable doubt is a fallacy. It's something you hear on TV. It's something you read about in a book. But you're right. When you go into court, and prosecutors will tell you the opposite. I mean, I hear prosecutors say all the time, people expect it to be like CSI. They expect us to come in with fancy computers and, be able to punch things in and kind of prove guilt that way. And that's not the truth either. I mean, TV shows have really done a lot of damage, I think, in terms of jurors coming in and what to expect when you're coming in and sitting through a jury trial. I mean, they're often quite boring.
Right.
The rise of true crime podcasts, I know Keith has on his notes about Netflix.
Yeah, I was
Right.
just wondering about Making a Murderer, because that I don't know how that fully ended, but I know that got a lot of momentum behind that he was potentially innocent, and then I don't think it had that ending in the end, right? He was kind of maybe I was wrong. Didn't he end up reoffending or something? Or
Well, they claim that he killed this woman
Right.
and burned up her body. I don't know, right? Like I always tell people when I'm investigating cases, I wasn't there. I don't know what happened. All I can do is follow the evidence. From what I've seen in Making a Murderer and Making a Murderer 2, I would venture a guess that he didn't do it. The evidence is subjected to being, potentially planted with the blood in the car. And certainly Brendan Dassey, who was named as his co-defendant, his confession, how that has stood up in court is mind-boggling. I mean, when you watch those tapes, it's just mind-boggling. It's a classic step-by-step of how police can get innocent people to confess to something that they didn't do.
Do you think that'll have an effect on how police interrogate, or probably not?
No, there is a movement right now in the United States. It's nascent, so we'll see if it gains momentum, of doing away with some of the trickery. So not lying to suspects, and interrogating people in different ways, right? Starting from an assumption that someone's innocent rather than they're guilty, and moving through every hypothesis and looking at the facts until you can reach no other conclusion but this is the person who committed the crime, rather than the confirmation bias and the tunnel vision that creeps in. So if I am interrogating you, Nathan, and I'm like, I'm convinced you committed this crime, tunnel vision is going to cause me to ignore everything that doesn't fit my hypothesis. Mm-hmm. And so there might be a lot of information that doesn't fit my hypothesis, but if I find enough that does fit my hypothesis, I'm going to run with it. And then when I take it to the prosecutor is only going to see the things that fit my hypothesis. And there's all this mountain of evidence over here that I didn't follow up on. Other suspects, things that don't fit my hypothesis. And then it might take 20 years in prison before someone uncovers all of that, follows it all up, and realizes you didn't commit the crime.
Incredible. You mentioned, and you'll have to forgive me, I don't remember the case in the 50s or 60s where they established that poor people have a right to a lawyer. Do you see something like that? Because it seems like, yes, now they're guaranteed lawyers, but it sounds like a lot of them, I just take this plea deal, let's get this. They just kind of want to sign the sheets and on to the next one. Do you feel like something like that needs to happen where we have not just representation, but quality representation?
Absolutely. And I've been very involved in changes, in working towards changes in the criminal legal system for decades. And we have made tremendous strides here in Michigan. I'm really, really proud of what Michigan has done. We have the Michigan Indigent Defense Commission. They are fantastic, and they're funded by the state. And they're putting in a lot of those protections and a lot of the training and money for investigators, for people to investigate cases. And so things are, Michigan used to be at the bottom. Like our quality of representation was worse than if you were arrested in Mississippi. That's how bad it was here. But with the passage of the Michigan Indigent Defense Act, the formation of the commission, all these great improvements that they're working on and are being funded, things are improving drastically and rapidly, I would say, for the good in the state of Michigan.
What's it going to take for those other states? Because we keep going back to this finality. Like it happens, the judgment's made, boom, done. Because the people who will make these laws are sort of part of the same machine. So what will it take for that to sort of have this change nationwide?
I think that's a couple of questions. So one is, we need a good, solid defense system for people who can't afford to hire a lawyer. Those people who do that work are heroes. It's very difficult work. They often have crushing caseloads, and they don't have the resources to hire investigators and do the job that they want to do. And so, I bristle a bit at saying, like public defenders are no good. There are so many extremely committed public defenders who work outrageous hours and give their all. But when you're overworked and under-resourced,
Yeah, it sounds crushing in a way.
It
right?
is. It's crushing, and things fall through the cracks. I mean, there's just no way around it. You can't keep up with 100 or 150 cases at a time that you're juggling. And so we have to change that. We have to properly resource and train prosecutors so they understand that they have ethical duties to justice. It's not about getting a conviction. It's about doing justice. And not being afraid to step forward and say, we've made a mistake, right? Before you convict someone. Like, I have found some new information, or new information has come to my attention. I don't think we can go forward with this prosecution. Empowering prosecutors who are at the trial level to be able to do that. So I think there's changes that need to be made at every single level. And then I'm going to go back to case and finality. We have to get away from finality as the overarching, impediment to doing justice. Does it create work when people can appeal? Of course. Does it create work to stop things? Does it create, are you inconveniencing maybe jurors and witnesses and different people? But we have to get it right. Mm-hmm. We have to have a culture where our primary concern is getting it right. And it's a grind right now. And so I think people get caught up in that grind. But I do believe things change over time and are changing. The advent of conviction integrity units, getting back to the original thing, is a perfect example. These units did not exist. Let's see, the first one was in 2007. So before 2007, there was no such thing as a conviction integrity unit in a prosecutor's office.
So I know the Innocence Project started in 1992. So it took 15 years for that to become an actual unit rather than just a project.
No, the Innocence, there's Innocence clinics and there's an Innocence Project. They're all doing the same work. They're just called different things. So Barry Scheck is widely viewed as the father of the Innocence Project movement. Your listeners may know Barry Scheck, might remember Barry Scheck, depending on how old they are, from the OJ trial. He was the DNA guy who came in and served on OJ's legal team. And he started the Innocence Project as a DNA project. How can we use this brand new technology of DNA to find innocent people in the system and prove scientifically that they did not commit the crime? And so that was the advent of the Innocence Project. And it's grown, I don't know how many projects there are, but they're all over the world. And it's sprouted all kinds of offshoots, right? So there's the National Registry of Exonerations. That's a database that tracks exonerations. They've tracked over 3,000. Let that number sink in. Over 3,000 exonerations. Not all of which are DNA. And so a lot of things started out with DNA because it's science, and people felt like, for this people who are skeptical of wrongful convictions happen, you can't really argue with the science, right? If I'm convicted of a crime and there's DNA left at the scene and the DNA is tested and it's not me, then it's got to be somebody else.
Yeah.
Right? And that's hard to argue with, although people do argue with that. I won't get into that, but it's hard to argue with the science, and then it's grown and grown and grown into the non-science and non-DNA cases, which could be, like you said, a recanting witness. Someone comes forward, or a new witness. Someone comes forward and says, look, I wasn't willing to come forward at the time, but now I'm dying of cancer and I need to clear my conscience. Or now I'm in prison for another murder, and so I'm going to tell you that I committed this murder too. So, you have to look skeptically at those things. Mm-hmm. People have nothing to lose in those situations. And, Nathan could be my best friend. And I'm in prison for 3 murders. I'm never getting out. Why not help Nathan?
Yeah.
And say that I committed the crime. And Nathan can tell me what happened. You can feed me enough facts that I can tell the story credibly. So from our perspective, that's never going to be enough, right? To recommend to the prosecutor that relief be granted. We are going to do a deep dive, and we're going to look at the police file, and we're going to see if there were other suspects. We're going to see if Nathan He's listed in the police file as a potential suspect at the time.
For the record, I'm not a criminal.
Yeah, I mean,
It's a lot of work. I guess my point is, people don't realize, like, people get mad at me all the time. Why does it take so long? I gave you everything. I've shown you I'm innocent. Why can't you just let me go? First of all, prosecutors' offices can't let anybody go. Only a judge can. You have to go to court, and it has to be a judge who signs an order and says, I'm going to vacate these convictions. The prosecutor's office can make recommendations. And we don't make recommendations lightly. I mean, as a result of our investigations, 36 men have gotten their freedom back. That's a lot. And most of those men would have died in prison. Most of those men were convicted of first-degree murder. They were serving mandatory life sentences, and they would not have gotten out through the traditional court system. But they were able to get out through the conviction integrity review system because we are looking for the truth. We are not bound by all the legal rules that apply when you go into court. And in Michigan, we are very lucky that we have both a freestanding innocence claim that you can make under the court rules, and we have a statute that allows the prosecutor to act in the interest of justice, and we have a professional rule of ethics that mandates that prosecutors do justice. And so if you find information, or if it's given to you, if you find it, however it comes to you, you are required to do something about it. So we are required to do something about it.
Those numbers are just incredible. I mean, 3,000, 35 people. And you talk about 50 years of each person. I mean, that's over 1,000 years of life. It's staggering.
Well, let me tell you about my first case, because that will hit you, and I think your listeners to hit home the point. Richard Phillips was the very first exoneration from the Conviction Integrity Unit. Richard Phillips served almost 50 years in prison for a murder he didn't commit. Not only was he in prison for a murder he didn't commit, he was in prison for an armed robbery he didn't commit. So he had a Wayne County conviction and he had an Oakland County conviction. The same person committed both of these crimes and was never tried. And there was a mountain of evidence to convict him that we found that the police ignored. And topper, the kicker, this person who committed both crimes was the only witness to testify against Richard Phillips in his murder case. So he committed the crime, put Richard in prison. And it took almost 50 years to get this man out.
Now, did Richard get monetary compensation? Because I see sometimes when these cases pop up around the country in the news, they say he got released after 32 years, but he got no money. It's like, sure, you'll take that rather than being in prison, but you feel like there should be almost a mandatory compensation for these people.
Absolutely. Imagine right now if you were to walk out of this studio with nothing but what's in your pocket and what's on your back. You don't have a car. You don't have a home to go to. You don't have a change of clothes. You don't have a toothbrush.
And the world's vastly different to what it was 20 years ago. You got to adjust to that.
That's right. And you have nowhere to go. And you have no money to do it. That's what it's like to be exonerated. You're in prison and then you're out. And you've got nothing.
How old was Richard when he was released?
He's like 77 now. So I think he was 71.
Wow. 21 years old when he went into prison.
Yep.
Yeah. So as you've been talking, I know we've talked about the finality of stuff. It's kind of made me think, and I know you mentioned CSI is, juries like things wrapped up in a bow. And, for those that watch Sopranos, that didn't end in a bow and people hated the ending, a lot of people, because it wasn't neat and tidy. Do you think the death penalty is part of that? People like a finality to things, and it's like, okay, you committed a crime, we convicted you, you killed someone, you die, move on, next one. Or, what's your personal views on the death penalty? Is it something you oppose because of people's innocence? And then what about people who are clearly guilty? Why would you, and I'm supposing that you oppose it, why would you oppose it?
I do oppose it. That's a good assumption. I oppose it because the system makes mistakes. I mean, people have posthumously been exonerated who have been killed by the state. because they were sentenced to the death penalty. And I don't think you can pick and choose. I don't think you can say this is an airtight case and therefore this person deserves the death penalty. Cases seem airtight when someone's convicted. And you don't know if they're really airtight. So in a system that makes mistakes, I can't countenance the state using its authority to execute anybody ever. And that's my simple, straightforward answer to the death penalty. I have worked on cases where the cases seemed airtight, like there's so much evidence against this person. And then you start unraveling, and they'll tell you something, whatever they tell you, just like Mr. Cooper, right? I didn't believe Mr. Cooper, but I had an ethical obligation as his lawyer to investigate it. I work my innocence cases the same way. People tell me things that I think are absolutely fantastical.
Right.
And most of the time I'm right. They are fantastical. But I don't reach that conclusion because I think that. I reach that conclusion based on the evidence. I interview the witnesses, or whatever it is, I follow whatever evidence I have to follow, and then I use the evidence to make a determination of whether or not the claim has merit or not. And there are some people whose claims I think do have merit. My gut tells me they have merit, but there is no evidence. I can't do anything about that. That kills me, right? That chips away at me inside, because I do think someone might die in prison for a crime they didn't commit, but I don't see a path forward to be able to prove their innocence. And so, this job is very difficult from many different levels, right? Like I spend time with the grandmothers who are crying on the phone to me about how they're getting old and they've got no one to take care of them and they need their grandson to get out of prison to come home and take care of them. And my grandson's innocent and he wouldn't do this. And then you look at the case and you're like, oh, no, he is not innocent. And then you have to tell him, like, I can't help you. Like, I can't help him. There's nothing that leads me to believe that he's innocent of the crime for which he's convicted. And the reality about my unit, you asked about people's perceptions. People often think about like a conviction integrity unit in the prosecutor's office. Oh, you're just letting people free. You were a defense attorney and now you're in the prosecutor's office and you're just letting people free. The numbers say otherwise, right? We've reviewed over 1,000 cases and the prosecutor has agreed to let me go into court on 36 of those cases. So that's not just opening the doors. These are 36 cases that sometimes took years to work up. There's a lot of evidence that supports the fact that the person is either factually innocent, like in Richard Phillips' case. We know that Fred Mitchell committed the crime. We know. I can say, I don't know. Again, I like to be careful. I wasn't there. Right? There's no video of it. But the evidence, all the evidence strongly suggests he had motive, he had opportunity, and that he's the one who committed the murder. And that's all I can do, right? Like, it's a heartbreaking job because I can't help everybody. And I do the best that I can. And there's heartbreaking stories. And there's cases where you look at a case and someone is, might have given a head nod to their buddy, like the coast is clear. And then they go home and their buddy goes and sets an apartment building on fire. And the guy who gave the head nod gets the same punishment as a guy who poured the gasoline and lit the match. Like, I don't think that's fair. But that's the law. And yeah. I can't change that. And I can't make that better.
Yeah. Well, Valerie, I could talk to you for a couple more hours. I mean, it's been fascinating. I guess to kind of wrap up, I mean, I was looking at some of the quotes from the original founders of the country, John Adams and Benjamin Franklin. A couple of their famous quotes that are attached to innocent work is, I'd rather 10 or 100 guilty people go free than one innocent person be wrongly accused or wrongly convicted. What do you think they would think of the system 200, 300 years on?
Oh, I think they would be appalled. Absolutely appalling. I mean, our system is founded basically on slavery, right? And it's people often say it doesn't work. But I was listening to someone recently who said it works exactly the way it's intended to work. It's intended to keep people down. It's intended, once you're wrapped up in it, to make sure you stay wrapped up in it. The consequences are horrific. The collateral consequences of a conviction can bar you from thousands of jobs, from being a barber to being a nurse to, anything, right? Like, the collateral consequences are astounding. And these are the things that people don't always know about and don't understand. So if you get caught up, even at a young age, in something, it can affect you the rest of your life. And it's really not a decent way to treat our fellow human beings, right? Like, I am a big believer in redemption. People, no one wants to be known by the worst thing you ever did. I'm sure you've done things you're not proud of. I'm sure Nathan's done things he's not proud of. I know I've done things I'm not. Every person has done things they're not proud of. Would you want to go around wearing a sign? Please, for the rest of my life, I want to be known as the kid who stole the M&Ms out of the 7-Eleven, right? It's like, and that's, I'm not trying to make light of anything, but I mean,
no, your point makes sense. Yeah.
People do things, and we know that, people's brains, you're not fully mature until you're 26. So do we really want to hamper young people who did something that they shouldn't have done, and they know they shouldn't have done, but maybe because of impulse control or some other reason, they did it. And do they have to live with that the entire rest of their lives? It's like a spouse who cheats on another spouse. Like, well, I have to say I'm sorry every day for the next 50 years if we're together. Like, when is it enough, right? When do you accept the fact that someone has changed, or allow them to show that they've changed and be able to move on with their lives? But if you have these things in place, if you lose your license and you can't get it back, well, you would need a job. So now you're driving without a license. And if you get stopped, it just becomes this, the rock rolling down the hill that's going to crush you.
Yeah.
And how do you get out from under that? So I think, to say the system doesn't work is not right. The system works. We need to find a way to rework it.
And are you optimistic you'll find that way?
I'll find that way. I'm not optimistic that I'll find that way.
Will the system find its own way to be better?
There's tremendous obstacles to making those changes. So am I optimistic? I'm generally a very optimistic person. So let me say yes, hesitantly. But I think that, one of the things that as a lawyer I do, and I hope, people I know there's big movements in the community to change the system, is I think it's critically important that we get everyone at the table. So we need people who advocate for victims' rights. We need judges. We need lawyers. We need community members. We need every stakeholder that's affected by the problems with our legal system to come to the table and work on ways to make it better. It can't be one-sided. It can't be the community saying, like, no more police. That's ridiculous. We have to have police, right? No more prisons. That's ridiculous. We have to have prisons. I mean,
right.
We have to have the structures and these things in place to keep the community safe. But they don't have to work the way they're working, right? So I think it's going to take a lot of commitment from people who are currently in power, police chiefs, and to change their organizational culture from, being, we have to arrest the bad guys, right? Everyone's a bad guy, to, realizing that people have mental health issues and we have to deal with that on a mental health issue, not just go in with the brute force, finding alternatives to guns like tasers or non-lethal, rubber pellets,
sure.
and different things that we can start de-escalation and figuring out together as a community. How can we work together to make our communities stronger? Because we're all stronger if we lift up the least among us. And if we can do that, and we can start working on those issues, and we can figure out how to get people into jobs and driving with their driver's license and removing all these barriers, we're going to be a much better community, a much better county, a much better state, a much better country. if we'd all just, work together to figure out how to put those fixes in place.
Yeah. Well, Valerie, thank you so much for your time. It's been fascinating. And you're officially our first Hall of Famer guest.
Thank you so much, Valerie.
Well, thank you for having me. I appreciate it.
Keith.
Nate, let's ruminate. Val, what an interesting guest.
Yeah, I mean, to really fully appreciate all she's accomplished, I think still might take some time.
Yeah, I mean, I was really interested in hearing about the Supreme Court, just some of the little peccadillos, if you were. It's a word I haven't used in a long time. Just the little things that you wouldn't know about, not looking at the clock, having to answer in certain order. That's almost like, a task on a game show where you've thrown all these questions and you've got to put them in order of who's done this. And it was crazy.
Yeah, it's almost like the argument was secondary to all this, like, protocol. And it's always like set you up to kind of catch you in all these different things when really shouldn't they be hearing the best argument and not worrying necessarily about don't look at the clock, don't do this. It was just really interesting. And also that she was so emboldened when someone would tell her, but you can't do this.
Right.
And she just, absolutely muscled through and did, I think you could say the unthinkable because a lot of people thought she couldn't do it.
Yeah. I mean, you mentioned the argument being second to the protocol. That ended up being like a theme for the whole podcast in that, do you really want true justice? And in a way, she was saying, the finality of the legal system, it's the protocol is what they want. They want to tie everything up in a neat bow and not necessarily revisit it. And obviously, I think it's getting better, but it's, slowly, the gears are moving slowly.
Yeah. And the way she described it, it's the finality of it has infected from the bottom when she described how the police were treating her, the one client she had who was wrongfully convicted, all the way up to the Supreme Court. Everything in between. But it's nice to hear that on the state level, at least, that her division within the prosecutor's office is at least trying to right some of these wrongs on a state level and not necessarily relying on like the ACLU or the Innocence Project or any of those things. Like we're being more proactive about saying, hey, we didn't get this right.
Yeah.
And that's encouraging.
Yeah. And that one thing I liked about her story, I think she mentioned a few times about how there's a lot of careers in law that can help people. And she sees the law and she went into the law to help people. And I don't know, because I never went into law, but sometimes you think, whether it's from TV shows or just, you've heard of rich lawyers, is that people go into law, they work endless hours at law firms, maybe they eventually become a partner. And I'm sure there's great virtue in a lot of that stuff. But to hear a path where she's focused on helping, being a defendant, helping the defendants, and then obviously getting to the position that now is inspiring. And I think highlights there is a pathway for that for people coming out of college.
Absolutely. There's the phrase talent is distributed equally, but opportunity is not. Right. And I didn't know much about different. We talked a little bit about her education background, and while Wayne State's got a really good law program, not everybody, like you're saying, if you have the means to go to one of these really great law programs, but you're well intended and you come out and you have loads of student debt. And she was talking about how much these these public defendants make and their caseload. It just seems insurmountable for some unless you have the means. And that's just something that she described she wanted to fix. And if anybody's going to fix it, it sounds like she's capable of fixing it, right?
Yeah.
She's just an impressive woman.
Yeah. And one thing we didn't even mention on the podcast is that she hosts this dinner every summer where it's a cooking competition between lawyers and judges. So she really does a lot kind of outside the courtroom to bring them together. We heard some of the stories of how they are separated and sometimes how you do run into issues with judges. And the one issue we heard was crazy in my mind.
To hear how blatant and just brazen he was in the courtroom about harassing. I don't think many names were mentioned, so hopefully.
No, and apparently that person is not a judge anymore.
Okay.
And I wonder, sometimes, because our reaction to it was when she said 10 years ago, and I think we were both expecting 20 or 30, any women listening to this podcast would be like, of course, you stupid man.
Exactly.
It's not, and I would like to say for my part, I do acknowledge this still goes on, but the brazenness of that in that setting, that sounded so old world to me.
Yeah.
I couldn't believe it was.
Yes. And we should also mention, and we can put it in the show notes, that she has a fundraiser coming up that we'll give you more details in the notes. But if you can support her in any way, you should.
Yeah. But even through the challenges, she just sees it as a challenge. She sticks to her values, and where, as she says, some people may not be comfortable mentioning it or dealing with it head on, and that's fine. She is, and I respect how she stays true to herself doing that.
Absolutely.
And one thing as well, we have our Instagram and our other channels open. Please feel free to comment any things you particularly liked or takeaways you got from this show and other shows. And I think with Val, actually, I know with Val, she's the longest episode we've done by quite a few minutes, but it's so interesting.
Absolutely.
So we try and keep these concise for you guys. Sometimes we'll split them up like Thad's, but hopefully whatever we cut them down to, you feel is interesting. And that's what we're trying to do with the flow. And I think we talked about it afterwards with Val. We may have her back at a later date as interviewing on a different aspect of the law.